Hi again. I had a terrible dream last night that people stopped suing each other. Seriously. The idea is to work to make it a reality, preventing lawsuits, which drain your money, time, and resources. Now, I'm going to give you my thoughts on the hashtag #MeToo movement and its effects on the workplace. I'll give you my perspective as an employment lawyer. I actually call this the hashtag #US2 issue because it affects all of us, employees and employers, male and female. 2018 was full of disturbing reports of alleged sexual assault and sexual harassment by prominent figures in business, politics, and even the judiciary. Not surprisingly, the number of charges of sexual harassment filed with the EEOC increased in 2018. The EEOC reported that charges alleging sexual harassment increased in 2018 by 12% when compared to 2017. This may be due to increased awareness that certain conduct is illegal. It may be because harassment is a hot topic. It may be that women and men are empowered to complain because they've seen so many others do so. No one can say. But it's safe to say that awareness of workers' rights to be free of sex-based harassment is at an all-time high. In data published in October of 2018, the EEOC reported that in 2018, it filed 50% more lawsuits regarding harassment than it did in 2017. These were lawsuits filed on the EEOC on the behalves of the charging parties. This means that the EEOC spotted a lot of issues which it thought were very troubling. The EEOC also reported that as a result of these lawsuits, it recovered nearly $70 million for victims of sexual harassment in 2018, compared to only $47.5 million in 2017. So the EEOC is very interested in this trend and is taking at least a number of the charges very seriously enough to file lawsuits on employees' behalves. What is workplace harassment? It is a type of employment discrimination. It is unwelcome conduct, whether verbal, physical, or visual, which is based on a person's sex, color, race, national origin, age, disability, or another prohibited basis under federal, state, or local laws. Note that many states and cities prohibit discrimination against more protected classes than those covered by Title VII. For instance, Delaware is a very inclusive state and covers sexual orientation and gender identity as well as other characteristics, in addition to those named above. This unwelcome conduct can take many forms, which we'll go over a little later. What is sexual harassment? Sexual harassment is a specific form of sex-based discrimination. It is harassment due to someone's sex, or even their perceived sex, or how they express their sex, such as harassment of a woman because she dresses as a man. There's a well-settled definition of sexual harassment as set forth in United States Supreme Court cases. The employer violates the law when an employee is subjected to conduct that includes unwelcome sexual advances, requests for sexual favors, verbal or physical conduct of a sexual nature when, number one, submission to such conduct is made either explicitly or implicitly a term or condition of the employee's employment. 2, submission to or rejection of such conduct is used as the basis of employment for employment decisions affecting an employee. Or 3, such conduct has the purpose or effect of unreasonably interfering with an employee's work performance or creating an intimidating, hostile, or offensive work environment. So, there are 2 types of sexual harassment. The first is quid pro quo sexual harassment, which is any physical, verbal, or nonverbal, such as gestures, conduct based on sex which affects the dignity of people, which is unwelcome, unreasonable, and offensive to the recipient. And a person's rejection of or submission to such conduct is used explicitly or implicitly as a basis for a decision which affects that person's job. This is the casting couch scenario in which a person is asked for sexual favors in exchange for a job. It's fairly straightforward. The other type of sexual harassment is called hostile work environment. This is defined as conduct by a coworker or other person in the workplace that creates an intimidating, hostile, or humiliating working environment for the recipient, where the conduct is based on the recipient's sex. If the person resigns, the employee must show that the atmosphere was so toxic due to the harassment that a reasonable person would be forced to resign. An extreme case I saw involved coworkers leaving a noose in a black employee's truck. Now that's an unusually strong case. Try defending that one if the employer knew about it. Remember, any person may be a victim or perpetrator of sexual harassment or sexual discrimination of any type. Gay, lesbian, and heterosexual workers can be harassed by either sex, regardless of the party's sexual orientation. What are examples of harassment? Offensive remarks, comments, jokes, slurs, threats, or verbal conduct. Offensive pictures, drawings, photographs, figurines, writings, or other graphic images. Conduct or communications, including text messages, instant messages, websites, voicemails, social media postings, emails, faxes, and copies. Yes, some people really are dumb enough to put this stuff in writing. I had a case in which the chef sent text to his prep cook. Offensive sexual remarks, sexual advances or requests for sexual favors, and offensive physical conduct, including touching and gestures. Honestly, the list is endless, but put those items in your anti-harassment policy, which you need, and I will tell you about this later. There are many, many things which coworkers may find offensive. Employees must be sensitive to the feelings of others and not predict what someone may or may not find offensive. Let's talk about some practical approaches to understanding this problem. Here's a really good test as to whether to make that remark or do whatever you're imagining doing. Ask yourself, and have your employees ask themselves, would I do or say that if the person's mother or spouse was standing next to them? Or how about this? Would I say that if my spouse or parent was standing next to me? Really, it's all about that mindset and getting people into that mindset. Everything else logically follows. 9 times out of 10, if you have the judgment of a reasonable person, you're not going to do or say something iffy when the person's spouse or parent is there. Please don't hug or touch people without asking. If you're a touchy-feely person, resist the temptation. If you think someone needs a hug, ask them if it's okay. Touching of any kind beyond a high five or handshake without permission is a very bad idea. I read about a recent case in which the manager was fired because he gave too many bear hugs. The employer was obviously concerned that they would be sued, which would literally be making a federal case out of the situation. Don't make comments about someone's personal appearance. No, that's not a good idea to tell a pregnant woman she looks great. First, she won't believe you anyway. Second, it may make her uncomfortable if she thinks you're scrutinizing her. What you think is a compliment may be completely turned around in someone else's head. And if someone persists in this with daily comments, this may be a hostile work environment. If you know someone well, and especially if they are on equal power footing at work, it's fine to say, I like your haircut once in a while. But that really should be the extent of it. What about romantic relationships in the workplace? I would strongly discourage or even have a policy prohibiting these relationships between supervisor and subordinate, regardless of the sex of either. It's all about the balance of power. The approach by the superior may be seen as a quid pro quo harassment situation. If the romantic attention is unwelcome, then it becomes a hostile work environment. If you don't prohibit it, then transfer the people so that they are not in that supervisor-subordinate relationship, if at all possible. Make sure to discuss the nature of the relationship with both parties. Tell them you've noticed or been told that they are more than friendly and ask if this is consensual. Try to read between the lines and encourage complete honesty. Keep the conversations as confidential as possible. I like the rule used by Google and Facebook. An employee may ask a coworker out one time. If the person declines, that's it. No more asking that person out, verbally or in writing. Doesn't that make sense? Then no one feels too pressured. So everyone says you need a written harassment policy and to follow it. Why have a harassment policy? There are important reasons to have a harassment policy. First, if it's implemented and followed, presumably it improves working conditions for employees. Second, it deters the behavior and prevents employee conflicts. Third, employees who feel protected from harassment and other discrimination are better workers. Fourth, it's negative for customers to witness unprofessional harassment or to be victims of it. Most importantly to lawyers, a company must have a policy and follow it to establish a defense to a Title VII, ADA, or age discrimination lawsuit. Employers must show that they investigated and promptly corrected claims of harassment. They must use reasonable care to prevent and correct harassment. I'll emphasize this point. Employers are on the line. The individual who harasses someone in the workplace is not liable under the federal laws. He or she's only liable if he or she commits a crime or independent unlawful act on the victim, such as intentional infliction of emotional distress. But he or she's not going to be defending a big discrimination lawsuit, the business is. The second part of the defense is that the employee unreasonably failed to use the preventive or corrective opportunities created by the employer to stop harassment. What does that mean? It means that an employee can't just sit back and wait for the harassment to go away, then hold the employer responsible. And if the employer creates a mechanism for the employees to report the harassment and gives it to all employees, then employees have no legal excuse for their failure to report harassment or discrimination of any kind. This is why it's important to have all employees sign an acknowledgement that they received a copy of the handbook, whether you make it available online or on paper. Get those signatures. This means that they were told how to report. Your policy should prohibit harassment based on any protected class of one employee by another employee, supervisor, or third party. Note that third parties, such as customers, should be mentioned in the company's policy. Harassment, which is not based on a protected class, someone is just being a jerk or a bully to all employees, must be discouraged also. An employee could perceive this as harassment of the group which they're a member. I represented a client in the hospitality space, which employed a manager who supervised a department in which all the employees happened to be women. Several of the women sued the company for sexual harassment, but we successfully argued to the judge that the harassment was not sex-based, thus not sexual harassment. The guy was just a jerk to all of his subordinates, not sexually harassing them. About $50,000 later, the client was off the hook and took our advice to fire the schmuck. What else should your policy provide? Number 1, provide for disciplinary action if it's violated, and document all of the discipline the employee receives, including verbal warnings, with dates and as much detail as possible. Provide that violation of this policy will result in disciplinary action, up to and including immediate discharge. Be strict. This should be a stern, clear warning. This is a zero tolerance policy. Number 2, make sure to clarify that the policy applies to every employee, including managers. Number 3, mandate immediate reporting of sexual harassment or discrimination of any kind, and provide several ways to do so. If you have a large number of employees, the company may set up an HR hotline for reports. If a smaller number of employees, it's best to say that the employee may report to his or her supervisor or any member of management, up to the CEO or president. The employee needs to report, and you don't want to prevent that by mandating that he report to his supervisor. What if the supervisor is the harasser or the person directing the discrimination? Number 4, give examples of harassment as I did earlier. Spell it out. What else is recommended? We say you should provide training once per year. This is what I've recommended for years, yet still get plenty of complaints from employees. As of 2019, training all employees is now required of certain sized employers in some jurisdictions, like Delaware and New York. Also, distribute and have the employees sign off that they received the policy every year. Put the date at the bottom of the document. Have a lawyer confirm that it still states the most current law. I can't emphasize enough how rapidly the laws in this area change. Each year I give this course, there will be changes. What else do I recommend? As I said earlier, provide that the company will investigate the report and then take prompt, appropriate remedial action. The company will attempt to protect the confidentiality of employees reporting suspected violations to the extent possible consistent with its investigation. Don't promise complete confidentiality. This is impossible if the employer conducts an investigation. because questions will need to be asked of witnesses and the purported harasser or employee who's acting in a discriminatory manner. Prohibit retaliation for reporting harassment of anyone, whether it be the employee himself or another employee. Spell out that retaliation includes threatening an individual or taking any adverse action against an individual for either reporting a possible violation of this policy or even participating in an investigation conducted under this policy. People are very scared to get involved sometimes. Here's a very important point. Do not penalize or retaliate against employees for reporting improper conduct, harassment, discrimination, retaliation, or other actions that they believe may violate the policy. Often, a charge of discrimination filed with the EEOC or state agency is meritless. There's nothing to it. However, resist the temptation to take any action whatsoever against an employee for filing a charge. As soon as an employer so much as changes the employee's hours, that employee may file a retaliation charge, which might itself be the basis for a lawsuit. I've seen this many times. Make sure that your supervisors understand this, even when the charge is meritless. Finally, be sure to specify that even non-employees are covered by this policy. The policy should state that it prohibits harassment, discrimination, or retaliation of company employees in connection with their work. Instruct employees to immediately report any harassing or discriminating behavior by non-employees, including vendors, clients, customers, and employees of contractors or subcontractors. Any employee who experiences or observes harassment, discrimination, or retaliation should report it using the steps you've outlined in your policy. Make sure that your supervisors are trained. There are a number of things to emphasize in training. They should be told to document every report of discrimination or harassment and report it up the chain. They should be told either to investigate or to follow your instructions. You might want an outsider to investigate if it's a very serious allegation. More on that later. But someone should investigate by speaking to the accused and possible witnesses, including every person named by the complaining employee. They must not discuss this with colleagues except in the context of any investigation. They should not be promising confidentiality, as I said earlier. There's no way to do a thorough investigation and not ask the accused and possible witnesses. Finally, remember what I said about prohibiting retaliation. This is a very dangerous area where I see a lot of liability. Don't let supervisors change any working conditions. Don't even fire the employee if the investigation reveals something terrible about their work performance. Check with an employment lawyer first. What about investigations? Quality of the investigation is paramount because the employer has to show that it did something to promptly correct the harassment. Again, I recommend, and I know this sounds self-interested, but that employers call an employment attorney experienced in investigations. Better to pay me a small amount now than to pay a plaintiff and his or her attorney tens of thousands of dollars later. Attorneys know how to question people and to get an impression of whether they're being truthful or not. I can even use some of my lawyer tricks to get them to admit to certain things. I'll know who to ask and what to ask. I can also review your documentation of discipline for all actors involved. I can then form a very good opinion of the case's strengths and weaknesses and help you to strategize on how to deal with the evidence. A competent HR consultant with experience in this area can do a decent job too. Ask your attorney for a recommendation. At a bare minimum, you want someone with experience at investigating these issues. I don't recommend using an in-house person. There are risks that this investigation appears biased, one-sided, or reflects favoritism of one employee over another due to a pre-existing relationship. Just talk to an attorney for advice in each case. I hope that these lectures have provided helpful information on this important topic. Be sure to follow up with any questions online or in the Zoom sessions.